So where we go back in time is to the date of the event causing the lawsuit. That might be that auto accident. It might be whatever triggered the lawsuit with your business partner. That is where we're looking at what you owned at that time. That anticipated or pending inheritance or lawsuit comes after that time. Absolutely. Those assets are within reach of your plaintiff.
This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show. I'm your host, attorney John Skabelund. Most of my clients come in thinking that their biggest risk is their business, their real estate, or their bank account. But in almost every case, once we sit down and do a full inventory, they discover they own things they never thought to protect. And those are often the exact assets a clever creditor's attorney will go after. Today, we're going to talk about the hidden assets problem. What you own that you don't know is exposed. So let's go through categories that people frequently miss. Category number one is intellectual property and digital property. Here are some examples: domain names, trademarks, patents, copyrights, licensing agreements. Real quick, a licensing agreement is an agreement where you are actually licensing your patent or copyright to a third party, and they're paying you income. Online businesses, content libraries, YouTube channels, podcasts, software, anything that is copyrightable. If you own it, it's exposed to your creditors. The second category are financial assets beyond bank accounts. This includes deferred compensation plans that are often not ERISA protected, non-qualified stock options and restricted stock units, future commissions, royalties or contingent payments, brokerage accounts, and promissory notes. I've had clients that have loaned money to family and friends, not realizing that although they would be patient if payment was not made, your plaintiff is not going to be patient. They have every right to take that promissory note, go to your family or friend, and say, although you are patient, I'm not. And now all payments are coming to me. If you don't make your payments on time, I'm coming after you. So with that in line, most of my clients, one of the very first things we are moving into their asset protection plan are their promissory notes. The third category are business interests. So minority ownership stakes in LLCs or partnerships, earn-out provisions in a business sale, and consulting agreements structured as deferred income all apply. Real estate is obvious, but what isn't so obvious to many clients is their primary residence, their vacation property, raw land, equity in a paid off or nearly paid off property is a prime target to creditors, as well as out-of-state properties. People often forget that these exist in litigation disclosures. The fourth area are expected or contingent assets. So if you have a judgment or pending lawsuit settlement where you're the plaintiff, that absolutely is exposed to your creditors. Life insurance proceeds you expect to receive as a beneficiary, or expected inheritances, especially if the trust is revocable and the person that would be giving you that inheritance is near death. Sadly, I've had the situation where a client filed bankruptcy just shortly before receiving a large inheritance, and that entire inheritance, worth 7 figures, went to the bankruptcy court. The fifth area is personal property. So paid off vehicles, RVs, boats, trailers, razors, airplanes, these are all subject to your creditor. Art and jewelry. And again, I would encourage you, don't look at the actual value of the art and jewelry. Think about if there is any sentimental value, such as an heirloom. And then collections. Many of my clients have very expensive collections, whether those are comic books, baseball cards, handbags, shoes, you name it. If it's valuable, a plaintiff can take it from you. Now, you may be wondering, how is a plaintiff attorney ever going to discover any of these assets? Well, I want to remind you that once the plaintiff has won the lawsuit, they are able to get what's called a judgment, a court order for you to pay their client. When they have that judgment, they can require you to a debtor examination. Under this examination, you have to testify under oath, under penalty of law, of perjury, that everything you own. Now, many clients don't also realize that social media and web searches will often reveal assets that you didn't even realize you were disclosing. And don't forget that the Secretary of State discloses your ownership in many businesses. Those searches are very easy. So in conclusion, asset protection begins with a thorough and complete inventory. Your asset protection attorney can't protect what you haven't identified. So in addition to physical assets, real estate, vehicles, boats, equipment, jewelry, art, you also need to include financial assets such as bank accounts, brokerages, retirement accounts, crypto. You must disclose business interests, LLCs, corporations, partnerships, sole proprietorships. Don't forget about intellectual property, trademarks, copyrights, domain names, content, royalties, YouTube channels. And then, of course, don't forget the contingent assets we discussed. Expected inheritances, pending settlements, deferred compensation plans, commissions. These all have value. And the fact is, if it's valuable to you, it's valuable to your plaintiff. So here are some questions that I've received from clients. Question number 1, what's the most surprising hidden asset you've discovered in a client situation that they had no idea was at risk? I had a client that collected original George Washington signatures. These signatures would be on letters or other documents. He was a history buff. This was his prized possession. And again, during the asset inventory, it came to light that he had this. He was so grateful knowing that if he was sued, that his George Washington collection was out of reach of creditors. Question number 2 is, how does a creditor's attorney actually conduct the search for assets? What tools are available to them? Well, as a former litigator myself, we would use systems such as LexisNexis or Westlaw. These databases are legal databases that will search Secretary of States and other government agencies for business interests. Furthermore, they will also search recorder offices in counties across the United States. So if you own real estate, it will pull up on these asset searches. Now, in addition to this, a plaintiff can hire a private investigator. A private investigator has the same resources, those legal online databases, but furthermore, they can actually follow you around and see what you're driving and what your day-to-day looks like. Question number 3, what happens to equity in a rental property that's unprotected? Can a creditor force the sale? Yes. So if someone is hurt on your investment real estate, even if it's owned in an LLC, they can still foreclose on the investment property. Your equity in that property is exposed to that plaintiff. There are ways to strip and protect that equity. But many of my clients, especially real estate investors, don't realize that one of the biggest assets that they have is actually the equity in their investment properties. Question number 4, if someone has a pending inheritance or a lawsuit where they expect a large settlement as a plaintiff, is that already at risk from their creditors? The answer is yes. So where we go back in time is to the date of the event causing the lawsuit. That might be that auto accident. It might be whatever triggered the lawsuit with your business partner. That is where we're looking at what you owned at that time. That anticipated or pending inheritance or lawsuit comes after that time. Absolutely. Those assets are within reach of your plaintiff. It's important that we're structuring your asset protection in a way that will take into consideration these assets. Question number 5. What's the first thing someone should do after listening to this episode to get their arms around what they own? Well, you need to do a thorough inventory. Any experienced asset protection attorney is going to provide you an intake form or questionnaire where you should be disclosing everything you own. And it's important that you're thorough with that intake. Now, even if you haven't disclosed it on that intake, a good experienced asset protection attorney will ask you follow-up questions to help you discover assets you didn't think about putting down on your questionnaire or intake. Well, with that, we're going to wrap up today's episode. It's important that you understand that asset protection starts with a complete picture. Before you can build a wall around your assets, you have to know what's inside. I encourage every listener to sit down this week and write out every asset you own, every account, every piece of property, every business interest, every income stream. Then review your current plan and make sure that it protects all of your assets, with the exception of what is required to be solvent. I remind you that you must remain solvent even after you've done your asset protection. A critical mistake is when clients put everything they own into their asset protection. If you do that, a judge is going to rule that you have purposely made yourself illiquid and insolvent and will blow up your plan. So it is important that you do it right with the help of an experienced asset protection attorney. So that will do it for today. Until next time, stay protected.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.